That brings us to item number 3. Item number 3 seems to be a duplicate of item number 4. Is there any objection to removing item number 3 from the agenda?
No objection.
And for point of clarification, Mr. Arnold, you prepared today's agenda? Who prepared today's agenda? Okay, there's no sponsor for any of these agenda items. Who is the council member sponsor?
I'm the sponsor.
Mr. Witz, your name should be appearing next to each agenda item as a sponsor.
Yes.
Okay, Ms. Arnold, please let the agenda reflect the actual sponsor, because our charter does require a sponsor for each agenda item. That brings us to item number 4. First read of ordinances prepared in compliance with item 2 above the delete from the Code of Ordinances, repeal sections 2-201, 2-202, 2-225, and 2-227, and also to delete sections 2-191 and 2-205. I believe in our Code of Ordinances, if you'll give me just a moment, please. In our Code of Ordinances, Section 2-116 says that when an amendment to this code is proposed and any council member or the mayor has been given fewer than 48 hours notice, including a copy of the proposal of the intent to introduce such an amendment to be adopted at a city council meeting, any council member or mayor may require by his own request alone that consideration of such proposed amendments be postponed until the next regular meeting of the city council. I was told of this amendment to repeal these ordinance sections on Tuesday, was just provided with the actual copy of the ordinance last night about 11 o'clock, so I'm requesting that I have at least 48 hours notice before we take any action pursuant to this ordinance section, and asking that this be placed on our next regular agenda.
Mr. Powell, could you elaborate on that, please?
The restriction is to a 48-hour voting time period for final consideration. This is a first read of this ordinance, and you'll have 2 weeks really before it actually comes up for passage. You can do ordinance changes. You could do it in 48 hours. You could read it on one day, pass it in the next, and that restriction is really designed to make sure that if you do that faster than 48 hours, you can delay it to a final vote. A council member is entitled to at least 48 hours for the full consideration. In this case, this is not a final action. This is just first read.
Mr. Powell, nowhere in the ordinance does it say only that first read does not apply. It says any action taken to amend the ordinance. That would be a first or second reading, as our ordinances require a first and second reading of all ordinances. So pursuant to 2-116, I'm asking that this be removed from the agenda. If the council wants to appeal my decision and overrule it, that's fine, but otherwise we're moving on to item number 5.
Take a moment, please. Mr. Powell, I always thought that it was second reading also, just like you did, but the mayor brought up a point here. Could you clarify, please?
It is final. The code section itself is dealing with a final passage of the ordinance. It gives you at least 48 hours for consideration from the start of introduction to the passage of it. Now, this is a very important part of the new clerk's protection. That's why it's on the agenda, is because there is confusion over the annual appointment issue, and only one place. Everywhere in our charter, it's very clear that that's an appointment that is indefinite in term. We've litigated for 3 weeks on the issue of whether or not that comes up as an annual appointment, and this is designed to repeal those provisions to vest whoever the appointee is in this job with a fixed position for their own protection. They need to know that as part of this appointment process.
Mayor, I'd like to make a motion to waive the first reading of ordinances prepared in compliance with item 2. that
Well, you
delete from
first
the
need to
code.
appeal my decision that this is removed from an agenda.
Then
Appeal
I'll
the decision.
make a motion to appeal that decision.
There's a motion, is there a second?
Second.
All those in favor signify by raising your right hand. That's 5 in favor, all those opposed, 1 opposed. The decision is appealed. Is there a motion on this agenda item?
I'd like to make a motion to waive the first reading of ordinances prepared in compliance with item 2 above that delete from the Code of Ordinances repealed sections 2-201, 2-202, 2-225, 2-227, and also delete sections 2-191 and 2-205. I ask that my motion is to waive this first reading and move it to our July 12th agenda.
There is a motion, is there a second?
Second.
Is there any further discussion? Further discussion? I obviously don't believe that this is open and transparent government. I believe that not only the council members, but the public have a right to see what this ordinance is or proposed ordinance. Getting something at 11 o'clock when you have an 11 o'clock p.m. when you have an 8:30 a.m. meeting, I don't believe is what is open and fair government. The ordinance sections, the open and transparent government, the ordinance sections that are to be repealed are 2-201 and 2-202, which deal with the annual appointment of the city clerk. And by council's testimony and trial, these were repealed in 2010, so I'm unsure if they were repealed in 2010 based on the testimony of members of this council, why they need to repeal them now. 2-225 and 2-27 don't deal with the city clerk, they deal with the city attorney. So this is an action to repeal ordinances dealing with the city attorney. And 2-191 deals with the city manager. One of the issues in court was why we have a contract for the city manager. 2-191 says that we should have a contract for the position of city manager to set his term of office and his compensation. And so this is an action to repeal that ordinance provision. And 2-205 is the provision that makes the city clerk the city treasurer, the issue we've been debating here tonight. Again, if that law was not in existence today, then by resolution, by Mr. Powell's own admission, we can't change an ordinance by resolution, and so Ms. Moreland Richardson would be the city treasurer based on 2-205, and there'd be no, if it's not in existence, there would be no need to repeal it through this. But with that, it's a first reading that will be waived until July 14th will be our next council meeting. All those in favor signify by raising your right hand. That's 5 in favor. All those opposed, that's 1 opposed. The motion stands approved. Item 5, is there, I didn't see the actual resolution for this in the packet. Do you know which one it is? Okay. Item 5 states a resolution approving the city manager's recommendation with regard to reconfiguration of the city hall office organizational diagram to provide an office of the city clerk and equipping that office with all necessary equipment, including but not limited to a copier and fax machine. Currently, the city clerk has an office on the second floor of City Hall with all of the other administrative offices. The city clerk has had an office there since City Hall was built in 2007, 6, I can't remember the actual date. There is no resolution. Is there an action on this item? Mr. Sanders, do you have a recommendation?
Mayor, what I was hoping to see come out of this meeting were two things. One, I was hoping that the mayor and council could take official action on the settlement which was reached in the court case last Friday evening. And the second thing that I was hoping for is that we could provide direction and guidance for Ms. Richardson as the new clerk and the staff as far as having the smoothest transition possible for the new clerk.
Mr. Sanders, what does that have to do with where her office is located?
As part of that, based on, as I said earlier, based on our previous discussions, when we were talking about going to a traditional city clerk's position and moving the financial responsibilities that Melissa has held out into a separate position, which could have been Melissa. We have Melissa's resignation. So looking ahead to the possibility of having someone take over those responsibilities, those financial responsibilities, it made the most sense to me to have that financially based person near our controller. And I have no idea who that may be. It very well could be Ms. Richardson. I would love to be able to have that smooth transition, work with Ms. Richardson, and find out that we don't need another employee. I have said almost daily that it takes all of the resources of a small city. It takes all of the skills, all of the brain power of all our employees to make it work. And so, but based on the discussions that we've had, all I was trying to provide was as much direction for Ms. Richardson as the new clerk regarding
Mr. Sanders,
when she starts.
the agenda item says that you have a recommendation. Do you have a recommendation as to where Ms. Moreland Richardson's office would be located?
That's what I was trying to say. If we are going to have the separate duties in a financial-oriented person, I'm recommending that that person be near the controller's office. And for Ms. Richardson, we have 2 offices downstairs, outside the mayor's hallway, and I'm recommending that those 2 offices be the clerk's office.
The suite that's labeled mayor's office, you're recommending that Ms. Moreland Richardson move her office in there?
That all be the clerk's office, yes.
And Mr. Sanders, there is a vacant office upstairs next to Ms. McKay's desk that was originally for the purchasing agent. Isn't that true?
There was what?
There's a vacant office upstairs that when Ms. Arnold was purchasing agent, she had an office next to Ms. McKay. That office upstairs is now vacant. Isn't that true?
It's a records holding office,
Okay,
basically.
but it's just used right now for storage space. It's not used as anyone's office.
That's right, it's very small.
And the actual upstairs, there's a whole section on the second side of upstairs that that's built out for office space, but that's not being used right now.
That's record storage also. I don't think that's been designated correct.
And so the administrative assistant who works with the city clerk and yourself and everyone else's office is located on the second floor of City Hall.
Planning and development, finance, correct.
But the executive assistant that works with the city clerk, who actually does most of the typing of the agendas and things like that, is located upstairs.
She is currently, yes.
Mr. Sanders has made a recommendation. Is there an action on the recommendation?
Mayor, I'd like to recommend that I understand the city manager's position about the finance department being right there next to Chan's office, but I think that we need the city clerk on the second floor also, and I'd like to see her put in that office behind where Karen's desk is, the office that the mayor is suggesting. I don't...
Well, now, Mr. Woods, I never suggested the city clerk go there. The city clerk has an office that she's had since she moved in. The purchasing agent office is rather small, and I think with someone of the city clerk statute, she is a city clerk. She is an administrator, an executive of the city. I don't think you should demote her to a smaller office, but is that your recommendation? You don't put,
You know,
I'm just
Mayor,
making sure you're not
you know,
putting words in my mouth. Mr. Sanders said.
putting any words in your
Mr.
mouth.
Sanders said, let me clarify, Mr. Sanders said that he wanted to make sure that if we hired a purchasing agent or financial person, that they could be located upstairs. That person would be lower than a city clerk. What I'm saying is there would be a purchasing agent office available for them, that there is not a need to move the city clerk out of her office to make room for a lower level employee if we were to hire such a person. So that was my comment. I want to make sure that's clear, but if you have your own recommendation, I'm happy to entertain it.
Mayor, you had an objection saying something about the first floor, which I agree with. So I made a recommendation that the city clerk be on the second floor. Obviously, now that's not good enough. I'm not going to tell the city manager where to lay out his people. All I'm saying is you did say that there is offices available on the second floor, and my recommendation is that the city clerk be retained on the second floor. If Mr. Sanders feels that that office, which was the city clerk's office, but also the clerk of courts and the IT administrator, all those other people, I'm going to let him lay that out. I'm agreeing with you that the city clerk should be on the second floor.
Is there a reason, okay. Is there any action to be taken on this agenda item?
I think I just said it. My recommendation is that the city clerk
Okay, so
should
there's
be
no
retained
action.
on the second
Right,
floor.
you're saying there's no action. I'm asking if anyone else has any action.
Well, I mean, my feeling is that Mr. Sanders is tasked to run the day-to-day operations of our city, and I think he's best suited to make those decisions. I'm certainly not going to move in the direction of explaining to him where he should put any of our valued associates at all. So I'm going to let him make that decision.
Again, is there any action? Do I have a motion on this agenda item? Is there any action we need to take on the recommendation? Seeing none, we will move on to the next agenda item. Action to affirm all contracts and minutes approved since January 1st, 2014 in their current form, bearing the attested signature of City Clerk Melissa Arnold, and authorizing Mayor Pro Tem Tom Witz to execute the same at such time as the law allows him to confirm the action, or in the alternative, allowing Mayor Couts to sign as required by law. Do I have a motion on this action?
I make a motion that we affirm all contracts and minutes approved since January 1, 2014 in their current form, bearing the attested signature of the city manager, or city clerk, Melissa Arnold, and authorizing Mayor Pro Tem Tom Witz to execute the same at such time as the law allows him to, or in the alternative, allowing Mayor Kelly Kaus to sign as required by the law.
There is a motion. Is there a second?
Second.
Second by Councilman Emmanuel. Further discussion? This is something that came out in the trial. Mr. Sanders, I believe at one point in time several times I've requested to know what contracts have been signed since January 1st, 2014 without my signature. Do you have those contracts? Do you know what we are affirming today?
I believe Ms. Arnold has those.
This is an issue that came out in the trial. Apparently, the charter says that the mayor pro tem can act, but only in the disability or the absence of the mayor. And I believe that Mr. Witz admitted during the trial that he has signed contracts erroneously, scratching out my name and signing them with his name. Council does not, in my opinion, council does not have the legal authority to go back and ratify his signature because it was not something he was lawfully entitled to sign. I have not been absent. I have not been disabled since January of 2014. I see that Ms. Arnold has a stack of contracts here. This is the first time I've seen this stack of contracts. I have no idea what these contracts are because they were not shown to me. They were simply given to Mayor Pro Tem Witz. I don't believe that council's taking this vote or taking this action today will in any way affect the fact that these contracts were improperly signed and executed by Mayor Pro Tem Witz at the time, and will not support this agenda item for that reason. I will, as I said, I will open this agenda item up for public comment if anyone would like to speak for or against the motion before we call it.
To make a comment, Mayor, based on your comments.
Okay.
I'll go after Barbara.
I just want the public to understand that the stack of contracts that either do not have a signature or there are several that have Mayor Pro Tem Tom Witt's signature on them, I just want to clarify a point here. Those contracts are not contracts that the mayor has not seen. Those contracts are contracts that were duly passed by a majority of this city council. And most of them, I would contend, I haven't looked, but I would contend that the mayor voted for those contracts as well. Under our city charter, it clearly states the duty of the mayor is to sign every contract or agreement or resolution duly passed by the city council. There is not if she feels like it. There is not if she feels like in her own personal legal opinion that it was unlawfully passed. The charter statement says the mayor shall sign. That stack of contracts are contracts that have been duly passed by this governing body since last December, and the mayor has chosen not to sign them. Thank you.
Ms. Bender, as I said, I haven't seen these contracts. They're just now being handed to me at the dais, but I believe that your counterclaim, which you agreed was abated, addressed that issue. Council chose not to present that counterclaim. This motion here today does not say that the mayor must sign those contracts. It authorizes the mayor pro tem, or it ratifies contracts as signed by the mayor pro tem. Again, the mayor, I'm not absent, I'm not disabled, so this is it is not a proper motion. It's not something that council has the authority to authorize the mayor pro tem to sign just because they want something to get signed.
Then I would contend that if you are not absent and you are not disabled, and those contracts have been passed by a majority of this governing body, then you should sit here right now and sign those contracts.
I'd also like to make the point that you were absent on March 29th. Mr. Witz was properly elevated to the position of mayor in your absence, and I believe that's when the contracts were signed. As Ms. Bender has stated, those were contracts that had been passed by the city council. You refused to sign them, was my understanding. It had to do with getting the city's work done. We needed to get the city's work done. You were absent. Mr. Witz signed them properly and in accordance with the charter.
Councilman Emanuel, I believe you're misrepresenting what came out in the trial.
I don't think I am.
It's a good thing, let me finish, it's a good thing there's a court transcript, we can all go back and read it for our reading pleasure, but what was testified to at the trial, there was a special called meeting on March 29th. The purpose of that special called meeting was for there to be a I believe Mr. Conway was there to present a Robert's Rules of Order seminar for members of the mayor and council and for members of our boards. There was nothing on that agenda for contracts to be approved or contracts to be signed. And what Mayor Pro Tem Witz testified to in court under oath was that he could not remember the dates that he signed some contracts, that he probably did sign them because they went into effect January 1st, 2014, but then he went back again and they were ratified on March 29th. And that's, you can't go back and change, you can't go back and say, oh, I did something improper, I did something wrong, but I'm going to go back and fix it by having the majority of council vote on it. If it was wrong in January, it's still wrong in March. There was nothing on that agenda, and there's nothing to reflect in the minutes that council ever authorized the mayor pro tem, even in March 29, 2014, to sign any contracts in the absence or disability of the mayor.
I would advise you, first of all, you're misstating. He testified to only one contract that he may have signed erroneously, not to the other contracts. There was some confusion as to the date for Mr. Sanders' contract. All the other contracts were a separate item altogether that were not debated about in terms of Mr. Witz's testimony.
Councilman Howard.
If it was wrong in January, it's wrong now. That's what I just heard. It was wrong in January to swear in a new city clerk. It was wrong.
Councilman Howard, you've dismissed that complaint. It was
Ms.
never
Counts,
resolved.
when I finish, you may speak.
Councilman
okay?
Howard,
Thank
I
you.
am the chair of this meeting.
Let me finish my statement. I have the floor. Thank
Councilman
you.
Howard.
It's real simple.
Councilman Howard, you
So-
are out of order. You will treat the chair with respect and decorum.
Ladies and gentlemen,
Councilman Howard,
I am going to
Take a
finish my
pause.
statement.
take a pause, Councilman
I
Howard.
am going to finish my statement. Okay? The contracts, the documents, the resolutions, the proclamations, all of the things that we have done since January have not been signed by this mayor. The commendations that we've given police officers, the commendations that we've given departments, the resolutions recognizing all of the good things that have gone on in this city have not been signed by the mayor because Melissa Arnold's name appeared on those documents. Melissa Arnold was our city clerk on January the 10th. Sitting here this morning, she remains our city clerk, and each and every document, contract, anything that we as this body have approved and voted on should be signed. I don't think there's any question about who our city clerk is and was during the first 6 months of this year. And to not sign those contracts, documents, resolutions, proclamations that show outstanding city employees doing their job, such as police officers, not having that name on there is just not right. So that is what this particular item is all about. Plain and simple. Plain and simple. She didn't have the authority to do what she did on January the 10th, 2014. She simply didn't have it because our charter expressly says that she doesn't.
Councilman Howard, the very first number one, the paragraph in the settlement agreement we're going to vote on in a few minutes says, the parties herein, in order to prevent further expense to the taxpayers of the city of Snellville, agree to dismiss the complaint and counterclaim in this case, and without admission of liability, further agree to the following terms. This is a compromise reached jointly by all the parties in an effort to avoid continued litigation. Last Friday, we said we were going to compromise. We were going to reach this settlement so we could stop going back and forth as to who had the authority to do what. We weren't determining who was lawful on January 1st. We weren't determining who was doing what action. This was a compromise to put it all aside so that we could move forward with the business of the city. And so far, all I've seen this morning is just continuing to throw the blame back at the mayor for taking action that you don't believe I had the authority to do in January. Not just from yourself, but from other members of the council. That was not the spirit of the settlement agreement, and that was not the compromise that we reached to go forward with the best interest of the city. So I stand by my statements that I'm greatly disappointed in what this council is doing with each of the agenda items today. This agenda item that's before us now authorizes the mayor pro tem to execute these contracts. It's not saying that the mayor has to sign these contracts. It's authorizing the mayor pro tem. Again, the mayor is not absent. The mayor is not disabled. There's no reason to take this agenda item today. If the documents are lawfully signed by a city clerk, I'm happy to sign them. There were proclamations that were issued without the city clerk's signature, without the city seal on it, that I signed over the past 6 months so that they could be properly given to the citizens and to the employees of our community that did good work. With that, again, like every other agenda item, I will open this for public comment. If there's anyone who would like to speak for or against this agenda item, please state your name and address for the record.
Madam Mayor, I haven't given any discussion on this. I would very much like the city attorney to set the record straight on some of the allegations and accusations that were just made against me for signing contracts illegally. There's one contract which the minute I was asked about it in court, I absolutely said that it was signed, but before I realized that I did not have the authority, I never said that any other contract I signed was done erroneously. Those contracts were signed duly, when I was duly in the position of mayor on March 29th. It did not have to be an agenda item, as you know. All it has to be is if I am sitting as the mayor at that time, there are contracts that have been approved by the city council that need to be signed in order to keep the city moving. They needed to be signed, and I signed them because the mayor, who was directed to do that, had refused for 3 months. Would you please explain some of the other accusations that were made?
With regard to that specific one, the settlement agreement actually deals with it specifically. It's incorporated into the settlement agreement.
Can you tell me where that is, Mr. Powell?
It's in the description where Mr. Sanders is being affirmed through December of 2015.
You're talking about the city manager contract, but it doesn't deal with the mayor needing to sign contracts in the settlement agreement.
The reference in the settlement agreement deals with the contract that you're speaking of. It's that one that you've affirmed in the settlement agreement as being a valid binding contract for the period through Mr. Sanders' term of December 30th of 2015. I think that issue is moot in terms of its debate and consideration, and that's not really what this agenda item is really something that I recommend to you. Obviously, there's differences over power issues with the council, but what we're trying to achieve with this action is to get the city's business back on target for the first 6 months of this year. You have an LCI contract that is pending that improves your Clower Street area that is in limbo. You have a paving contract with our Snell family that is paving the streets of the city that is in limbo, and these outside contractors need finality.
Mr. Powell, that's not accurate because there have been notices to proceed sent to those contractors.
In terms of the city records, they're entitled to a signed agreement that evidences that relationship, not a notice to proceed. And for that reason, it's written to really ask the mayor. This resolution really does put the request, the final paragraph says, Mayor, it's your responsibility, section 2.294, to sign these agreements. Mrs. Arnold's name appears on them already, and they've been approved as to form by the city attorney, which are the other legal requirements. And so it is let's put our contractual situation in order while our sitting city clerk, Ms. Arnold, is authorized to close the books and before the mayor's new designee takes office. So it doesn't place those burdens or shift those responsibilities, and we close out our books with our contractors that we have voted on and agreed to do business with. This is a business consideration. It's not a part of the dispute between the parties. It is just putting in order your records with your city clerk attested properly so that every one of those contracts can be performed. I believe this, regardless of the signature that appears, I believe this cause of action will give all of those contractors the finality that they need in order to proceed with the business that was done publicly in front of the people at every council meeting from January to June. And so this is really a bookkeeping, a records provision. It's not a part of the dispute, and it's something that I highly encourage passage of in order to keep the credit rating and the good business rating service of the city of Snellville in good order.
I will call the well, is there any other public comment? I see none, I'll call the question. All those in favor of the motion as stated, signify by raising your right hand. That's 5 in favor. All those opposed, 1 opposed. The motion stands approved. That brings us to item number 7.